Wading pool. The reason I want to highlight this is here, when we had the outbreak with E. coli, they had a standard in place. They had their pool code right there. They didn't follow it. Now, the first thing the county said was when this outbreak occurred was the county is not negligent. The lawyer said, you don't think you're negligent? Right here, here's your code. Right here, you were supposed to do this. You did not do that. Therefore, the county was negligent, and they ended up having to pay that one. Okay, so we got a legal standard of care. This is where we start understanding the law. I was injured. The product was defective. The product caused my injury. That defect caused my injury. That is strict liability. You operate a swimming pool. The person was injured. It was caused by your swimming pool. That action at that pool caused my injury. You're strictly liable. That's all they need to do. That's the essential standard. Now, there are a lot of caveats to that. There are a lot of issues to that before you get there. This is the basic tool. The point I want to bring up with that is, with such a low standard of care, with such a low standard, to bring a case before a court, it really shows the problems with trying to basically regulate and operate your pool when that's your standard. It can be anything. And as I see here from the California Department of Parks and Rec, this is the one thing that they really were highlighting in when they were starting to talk about some of their regulations, was that legal precedence has a wider application in areas without statutory standards. That was their argument. It's like, if there are no standards out there, if you do not have a code, if you're not following any federal guidelines like the ADA, if you're not following any industry guidelines, if you don't have to, that's fine. You're not regulated. You're not in violation of the ADA if the ADA doesn't apply to you. You're not in violation of the MAC if the MAC doesn't apply to you. You're not in violation of Kentucky swimming codes if the swimming pool codes don't apply to you. But the problem is, then you are subject to whatever the jury, whatever the court, whatever the attorney puts in front of the jury. And that's a very, very troubling standard, because it makes the standard of care unpredictable. You don't know what your risk is. Reasonable person standard. How many of you ever heard this? If you ever get in front of a jury or ever get to a court, you do the reasonable person, reasonable standard of care, which is the degree of care that a person of ordinary prudence would exercise in the same or similar circumstances. The standard which a property owner must observe to avoid liability for injuries to patrons. This is what a reasonable person will do. Now, if that's your standard for operating a pool, how much latitude do you have there? How wide can it be argued that you have been unreasonable? It's all over the place. There's nothing to hang your hat on here. There's nothing you can go to a jury to say, look, this is what everybody does. This is our standard. This is our industry standard. Nobody has a lifeguard on duty. I don't care. It was going to be reasonable for you to have a lifeguard on duty. Everybody knows that you're not allowed to have people dive. We took down all the diving boards. I don't care. A reasonable person would not have that. Is there one reasonable person on the jury who has ever been involved with an aquatic venue? No, it doesn't matter. We know what a reasonable person will do. This is a really tough standard to defend against. And it's a very easy standard to charge someone with. And this is the basic standard that you have to deal with if you do not have any codes, any laws, any requirements to back you up to say, that's not the legal standard. The legal standard is a statutory standard over here. It's a really wide open. The standard, basically the legal precedence put forth is, did you know, did the owner know, or should they have known about that their venue could cause an injury? But for the action of the owner, the plaintiff would not be injured. Very broad, very wide open. The reason I want to bring that forward is that you have a situation in this state. And let's pretend you don't have any codes that are applicable. You are operating a spray park out in the countryside. You're not subject to county codes. You're not subject to state codes. You're not subject to the Model Aquatic Health Code. You're not subject to the ADA. Something happens. You are following the standard of care. The trick is, should you have known this to happen? Well, yeah, you're running an aquatic venue, injuries occur. What's your standard of care? Well, hey, none of these things apply, so I don't have a standard of care? Wrong. You should have known that this action would have caused a problem. You should have known that the state of Kentucky has standards that you could have followed. You should have known that the Model Aquatic Health Code has been implemented, and you could have followed that, but you chose not to. Because you chose not to, you are now going to be considered liable. That's where these new standards that get adopted or get developed, even though they may not be adopted in your jurisdiction, they de facto get accepted in your jurisdiction because the court of laws make them accepted. Statutory standard of care. Now this is not based on the reasonable person. This takes precedent over the reasonable person standard of care. This is when you have a law on the books that says this is what the standard is. If the pool operator is doing this standard, if the pool operator is following the Kentucky State swimming pool codes, therefore, he is not liable. He did not act unreasonably. We have defined what a reasonable person is, and therefore, they are not liable. Now, as I said, there is no situation where you will not be liable, but here's a situation where you will be less liable and may be able to avoid those big ticket items. It is the strongest, it's your strongest case to make when you're in front of a jury to say, these were the standards adopted by the state. I followed those standards to the T. I implemented the program. I followed the procedure. I am correct. This happened because the guy was running and jumping into the pool. This happened because people were negligent. The plaintiff was negligent. I was not. We ran it as clean as possible. That is a strong argument to make to a jury. It defines, as I said, it defines the legal standard of care. Industrial standard of care. Can industry come up with a standard of care? Absolutely. The International Code Council, they design standards. You build your pool, you make sure that it's following a certain code, it's following a certain standard. That puts alleviates a certain burden from you in case something happens. We have a chemical spill, we have a release of a certain type. If you built the pool to these codes, you have an argument saying we followed the industry standard. What about public health? Well, this is the other aspect to this that people don't talk about too much, is that the International Code Council is designed to protect buildings. It's designed to make sure buildings stay upright, that if a hurricane or a tornado or a flood or a fire breaks out, that the building is maintained. It protects the health of the building. It does not, these aren't standards that are designed to protect the public's health. So even though, and I'm sure many of you realize this, you have built your aquatic venue to the absolute proper construction standard, does not protect the patrons in the pool. It protects the structure. It may incidentally protect the patrons in the pool, but that's not what it's designed for. The Model Aquatic Health Code, which I'll let Jacinda talk about, is designed for that.